Hi everybody, Jack Meligan with you again from the Plaintiff's MSA and Lien Solution in rainy Portland, Oregon. Today's video is entitled Love Letter from Medicare, and what I've got in my hand to show you is an actual Medicare Summary Notice sent to a Medicare beneficiary, and this outlines Medicare Part B services that were submitted for payment. And what's really interesting about this letter is I have heard many times from attorneys that they're going to ignore these Medicare issues, and especially the MSA issue, which covers future Medicare conditional payment possibilities. They're going to ignore it until they've got proof that Medicare is actually engaged in any kind of enforcement action. Well, here's our proof. And what I want you to see is this yellow highlighted area down here with the red circle. And I don't know how that'll show up in the camera. I'll hold it a little closer. But I'll read it to you, because this is the most important thing about this letter. Besides the fact that up here, Medicare says under the column service approved, no, then they give their reason down below. And here's what they say. Your claim has been denied by Medicare because you may have funds set aside from your settlement to pay for your future medical expenses and prescription drug treatment related to your injury or injuries. So here's your proof. Medicare, as we've said many times, is charged with denying payment. They are precluded from paying once your client discovers they've had a settlement. And the problem with that is that Medicare can also take the position that if your client did nothing at all to consider how to protect Medicare and the Medicare Trust Fund, then Medicare can take the position, if they want to, that your client must expend the equivalent of the entire settlement that you got them, including the amount that the client paid you for attorney fees. So it's the gross settlement, not the net. Medicare can require that they expend that entire settlement on Medicare allowable expenditures before Medicare will ever step in and pay a dime. The alternative is, if this client had created some sort of a Medicare set-aside arrangement, and a Medicare set-aside account, by the way, is just one possibility. There's at least 7, maybe 12, maybe more different options under the heading of Medicare set-aside arrangement. But if they had created something and the bill had gone to their Medicare set-aside arrangement or account, it would have been paid and not denied by Medicare. If enough of these types of bills are denied for any one claimant, you can imagine the panic and the anxiety that the client's going to feel, because many of our clients, 90%, have gone through all of their settlement proceeds within 5 years. And if Medicare starts denying payment and the client has no money to pay the bills, that's when you're probably going to get an angry phone call from a client saying, what happened? I thought you said I was going to be taken care of. I didn't need to worry about these Medicare issues. What happened? How am I going to pay my bills? It doesn't have to be this way. There are 3 ways to avoid an MSA legally and get Medicare on the hook from day one. Absent that, we are the experts in delivering minimized MSA allocation amounts from qualified medical personnel, so that your client's settlement only has to fund the very smallest amount for future Medicare and Medicare allowable bills, and doesn't have to expose their entire settlement. We're here to help you. It's not going to be painful. Give us a call. We'll walk you through it. This has been Jack Meligan for the Plaintiff's MSA and Lien Solution. See you again soon.